In the United States, this would mean nothing more than saying the Patent Office ought to live and die by the Administrative Procedure Act. There should be cost-benefit analysis of major monopoly construction in the economy. Ask what the good of it is, ask what the harm of it is. Where the harm outweighs the good, do nothing. Where the good outweighs the harm, do what makes the good and limits the harm, which ought to include flexibility of terms in regard of where it is that the tipping point is arrived at between the costs and the benefits, which surely is not at 20 years for each and everything in the world. That's the whole point of all the technical discussion in the first place. Do this the way you decide where to put a road. Do this when you decide, the way you decide how to use a water treatment plant. Figure out whether the public's benefits outweigh the costs and act accordingly. We could simplify the process of patent reform to the point at which both the man and the street and the legislative aid could understand deeply what we want and why we want it. We won't get it because the forces that like the patent system are not interested in subjecting their activity to the test of the public interest. But that's exactly what politics should be about. We are not even close to getting there because all parties still insist on the discussion of technical reforms, which is really shape of the table discussion. This is really discussions about thinking about agreeing one or another of these days. We will know that we are heading out of that period and towards real progress when parties are prepared to adopt a brief and simple statement of what they are seeking, which is to resubject the patent system to the pursuit of the public interest. When that principle, when that meme begins to gain endorsement, we will have turned the corner. Where I think that meme could most likely come to dominate the political discourse is here. It would make sense for it to be here. It would make sense in connection with any reasonable human resources policy for India in the 21st century. It would make sense with respect to the prevailing politics of uncertainty about the role of MNCs in domestic politics. It would make sense with respect to the fact that, if you will pardon me for saying so, the primary sources of venality in Indian politics would not be touched by it. The control of the United States Senate hinges on the senator from Pfizer, Mr. Lieberman, more thoroughly owned, if you'll pardon my saying so, by Pfizer than any senator is owned in the United States by anybody. That is not the problem here.
Actually, let me add to that. We met the Commerce Minister at that point in time, when the Patent Amendment Act was being formulated. The first comment he said was, all the multinationals are really approved, and Pfizer was one of the names that you mentioned. So it was a real tough challenge for us to really get the software part of it out. I guess, but the question that I would still like to ask is, what can India do to fight this in the global? Because eventually this will move to TRIPS, it will move to WTO and other battlefields.
I think what Venkat is also saying is that perhaps many of us here are not as confident as you are of the ability of the Indian government to resist pressures from multinational corporations in more ways than one.
Yet,
also add one more dimension to, I want to hear more about the heterogeneity itself creating difficulties. Because heterogeneity also means, you had you had a kind of freedom, right, in the mother country when you were colonized, right? The same laws do not apply to us. So we are actually quite in love with the American way of life these days. So where is the heterogeneity and the localization aspect of the software? How does that actually, I wanted to hear more, pose a challenge. So all those things, spiritual and all those things are good things to hold on to. But how do they translate actually, when art of living itself is a commodity, in ways more than one? How does that one,
Yes, just perhaps I will take all the questions together.
yeah, I think there are probably other speakers who could usefully be joined, in fact.
Yeah, hi, I'm Varun. I run a small software company, and we're in the business of developing products on open source solutions, specifically Linux, which I would have referred to as GNU Linux if Stallman were here. And that too in the field of digital home technology. So essentially the multimedia battlefield is what we're faced with. I intend to play the devil's advocate here because to an extent I have a feeling that we're preaching to the choir here. But you know, there are some specific issues I'd like to take up. Now the first thing I'd like to understand is that the FSF or the Software Freedom Law Center is not against intellectual property protection per se. Is it? Is it particularly? Is it against patents? Is it against how they're applied?
You know, it seems to me if that's meant as a beginning of a chain of inferences that we should try not to get to the point where you think I've welched on you 2 questions down. So I ought to begin by pointing out that there's a binary opposition implicit in the question. You are either for intellectual property protection or you're against protection. The primary problem isn't whether we have legal regimes that are intended to support those who make intellectual progress for the community. The primary problem is the use of property conceptions to achieve that result. Property conceptions imply exclusions. Exclusions imply deprivations. Deprivations are justified faute de mieux because you knew no other way to help creators but through exclusionary rules, which as a secondary bad consequence gave you deprivations. I'm working quickly because I've written this out so many times and I know I would be boring people if I repeated it. So in order to answer your question, I need to point at the third way in between. The property rules are never optimal anymore. They're always morally troublesome. And all of the beneficial consequences of the property rules can be achieved by other legal devices to protect creators' interests, which don't imply unfair deprivations or unnecessary exclusions. I'm sorry that it isn't simpler than that, but that's the way it really is.
Okay, but then my question would be, why would you not push for cost-benefit analysis of copyrights, of trademarks, of trade secrets? Why just patents?
In fact, the reasons that you do push for those things, but in slightly different ways, is that the nature of the interventions is different. In the case of trade secrecy, remember, the fundamental limitations are determined by contractual obligations between parties who have voluntarily agreed to keep secrets. And the issues of primary concern to us are when is it in the public interest to go beyond the bilateral bargain. A guy who signs a non-disclosure agreement and then breaks it can safely be left to the ordinary course of contract law as far as we're concerned. We have no need to impair the obligation of a promise of confidentiality. Where the goal is to impose a third party's responsibility to prevent him from disclosing what he has learned, though he has never agreed with anybody else, the rather sticky and obscure area of third-party consequences of non-disclosure agreements, we do fight the law of trade secrecy. I remember standing in a courtroom in California discussing John Johansson with a California judge over the question of whether the DVD CESS program could be disclosed by third parties who had never promised nothing to nobody, all right? With respect to copyright, the limits of the public interest are the definition of GPL. They are the demonstration of why private ordering is superior to the strengthening of copyright through additional contractual obligations. But because copyright involves control of only an expression, not an idea, which is our Supreme Court's one remaining constitutional certainty with respect to copyright, we have much less of a difficulty protecting the public interest. If we protect the public's interest to reinvent, redevelop, and redescribe, we can safely leave the author to even the overprotective bargain currently afforded by the state. We satisfy ourselves by merely returning to the public that portion of the bargain that we no longer need. The consequence is not that we abandon the other areas in which law might go wrong, but we have simpler solutions. So there, I'm afraid, at the second step in your chain of inferences, we also find ourselves in the it's not so simple turf.
Because what's happening is,
Let us recirculate the issue. I promise I will be responsive before it's done.
I would like to make a couple of small points. One is that I think fundamentally we are seeing a change of capitalist behavior itself. Capitalism in the United States today is looking to rent-seeking rather than productive use of capital. And that is not, the discussion is not about a so-called American way of life, but the way capitalism itself is changing its behavior, and that's what we really need also to address. So I think when you look at pattern behavior, the issue really is that you're looking not at production, but at rent. And that's where we come into, I think, in some sense, the picture. The second part of it, I'd like to say that as far as India is concerned, we must understand that we are seeing a patent office which used to think that public good is denial of patents, if possible, to a situation where they think public good is served by giving more and more patents. This is a very, very significant change taking place in the Indian Patent Office, and for the information of the people sitting here, they must know that the broom, the jharu, has been patented in 2007. The description is exactly that of a broom with a handle, with some semi-flexible stuff coming out of one end, tied up with a band. This is the patent description. It's been patented in 2007. So you have trivial patents. Pardon?
Along with the working model?
The working model is very simple. Okay, in this case, that would not be a problem. But the point is, the Indian Patent Office, the Director General is on record repeatedly saying that he thinks patents are damn good for India. And the Patent Office today is moving in the direction of the United States Patent Office, which patented, I think, swinging on the swing by a 5-year-old child because the father had drafted the patent. So we are really into that kind of regime. The third point I would like to make is we have something like 450 software patents, some tied with hardware, some independently, which are in the pipeline, and about 20 which have already been granted. And we need to do something about it, because looking at what has been submitted, and Microsoft has about 5 of those petitions, looking at what has been submitted, a number of them are really just for software. And it would be wrong to think that this Indian patent law does not have software patents. It says software per se is not patentable, which means that the patent office can interpret it to say software which is intelligent, which is X, which is Y, which is Z, can be patentable. That's a battle we have to still fight. We would like to interpret that software per se is not patentable, means that it's not patentable unless it's embodied in something that when you shake, it makes a noise. So that's what our interpretation. Necessarily the patent office interpretation may not be this.